Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, looking at a book which has come to us from Routledge, which is a Taylor and Francis Group company, and it's got an intriguing title, Adjudicating New Governance, and it's got a subtitle, Deliberative Democracy in the European Union. It's been written by Emilia Korkea-aho. I do hope I pronounced that name correctly. Now, this is a GlassHouse Book publication from Routledge. My wife Elizabeth and I have written a review, and we gave the review title, Good Governance in the European Union, Adjudication in a New Legal Era. Because I frankly have to say, when I first looked at this book, I had some problems because I wasn't quite sure what the learned author was actually talking about, to be blunt, and I think it's fair to say, because what does she mean by adjudicating new governance? That's the book. It's a hardback. There's the back of it. It's not a big book, 250 odd pages. There's the index at the back. You've got the body. You've got a very, very detailed bibliography, which is a very, very hard amount of work has gone into it. Literature to start with, and a whole range. This is given the classification law and politics, which is a right classification. You've got some footnoting, as you can see at the bottom of the various pages. You've got paragraph numbering at the sides with subheads, which again makes it easier to find things quite quickly. You've also got at the front, there's the main front page. Then you've got the contents, and you can see there's the first 3 chapters, and it runs through from that to 7 chapters in total, and those are the various titles. Then there's some acknowledgements. Then you've got a very useful list of abbreviations. Always look at them, because like everybody, I can get very confused with some. You just have a slight block, you can't quite remember, so the abbreviations are very, very useful, especially in anything to do with European Union law. With respect to all of the people concerned, I do find it quite complex sometimes until you sort of spread your way through it all and you get to where you are. There's chapter 1, out with the courts, in with new governance. And again, 2, new governance in the European Union, and so on. And it runs through, and as I say, you can see all of the nice detailed footnotes throughout. I've been impressed with this book because when I understood what Emilia was trying to do, all became a lot clearer, because initially I wasn't really quite sure about what we were talking about, because what is deliberative democracy? We know what the European Union is. New governance. In other words, what we're looking at is a new way of adjudicating, in other words, making decisions affecting member states and in fact their relationships with each other, under the way in which the European Union is going to actually progress and mature as the years go on. In other words, the deliberative democracy in the European Union, it's to make it, if you like, more democratic by looking at new ways of making decisions when there are conflicts, without recourse to the courts, which to most people will be a very good thing. We have the same approach in the civil jurisdictions, certainly in England and Wales, where we are trying very hard, where possible, to mediate disputes without the need to have the full-blown litigation process, which can cost a great deal of money. It's very, very time-consuming. It's tremendously nerve-wracking for the people involved, and it, at the end of the day, may not solve as many problems, whereas if you can find other ways of doing it, you might well be in a position that you get the parties recognising that that is the best way forward for the determination of a dispute. Now, having said all of that, that seems to me to be what Emilia has been doing. But let me explain from our review what we think the merit of the book is. Examining the legal landscape of the European Union from a decidedly panoramic standpoint, this remarkable piece of scholarship and analysis by author Emilia Korkea-aho offers international lawyers, political scientists and certainly policymakers a new account of the role of the EU courts in new governance, connecting it at the same time with the concept of what is called deliberative democracy. Now, deliberative democracy and new governance are, of course, terms that are subject to a number of interpretations and therefore defy any impulsive attempts at precise definition. In fact, the author admits, quote, that no commonly accepted definition exists of the meaning of the term new governance. But don't despair. She does add helpfully, and we summarise here, that the concept is not a legal notion and that originally it was popularly known as good governance, as advocated, she adds, by the World Bank and the Organisation for Economic Cooperation and Development, the OECD, from the 1980s onwards, so it's not that new. By the turn, however, of this century, I'm recording this in the spring of 2015, however, the new governance, which we now have, has come to be regarded as possessing certain salient characteristics, too numerous to list here, but which include participation and power sharing, cooperation and dialogue, that's between different levels of government, diversity and decentralisation, and flexibility, experimentation and knowledge creation. And the latter emphasises the new knowledge created from deliberative processes and peer review. So new governance then is an evolving concept which in turn connects with the concept of deliberative democracy, if you can conjure up in your minds what those two terms will probably mean to you. Discursive, closely argued and thorough. This book, recently published, as I say, by Routledge, is nothing if not forward-looking, and we welcome that. The author, in short, has offered at least a partial view, or a vision possibly, of the way in which the EU can or might or will be governed. And that's, of course, in the future. She alludes to the extensive experimentation going on in the attempt to formulate new ways in which the EU might conduct its business when, for example, conflicts arise between member states. And that effectively is how I began the introduction to the book, because that's where the bigger conflict areas can be between member state X and member state Y. However, do such situations, including environmental conflicts, big area in its own right, call for an adjudicative stance that is legally determined by the judges of the Supreme Court of the individual EU member states? Or should the basic principle of deliberative democracy, which features the ascendancy of elected officials rather than unelected judges, reign supreme? You're always going to have that problem. Again, we do have, of course, in England and Wales, the general view that law must be seen to be done and it must be open. There should not be secret deals or decisions being made behind closed doors. That, of course, is another area where you might be looking at the concept of deliberative democracy. Deliberate in the sense of trying to open it so that it is actually open to all, so there's no secrecy. These and a multiplicity of related issues are examined and discussed in this book. It helpfully draws on a series of illustrative cases and their studies actually to argue, among other things, that collaborative frameworks can and do condition judicial decision making, because that is the end result. Thus, the book supports the view that far from undermining the power of the court, governance regimes actually assist them. And I think that's partly the jurisprudential point of the book, where there's the merger between law and politics. It's a formidable work of scholarship. You should note, of course, the 30-page bibliography, which has taken the author 5 years to write. It's at academic institutions across at least 5 cities, from Helsinki to London to New York, Columbia Law School, Florence and Amsterdam. Let me conclude by saying the book's intriguing international perspective will make it useful for a range of academics and legal professionals concerned with one of the most interesting phenomena of our times, the really quite exciting evolution of the European Union as a fully fledged political entity. Now, obviously, that is not going to go down well with quite a large number of minority political parties within the EU, and we are facing a general election as I record this review. But the point remains that we have the evolution of the EU. Whether the UK is part of that eventually or not, we don't know. The likelihood is we will. The point being that it is evolving, and this book is a great contribution to what I would term the ongoing debate. The publication date is set at 2015. I haven't got a more detailed date than that. There's the book again. Spine, nothing on the back as such, but there is the law and politics section. It is partly a jurisprudential book. Right in the middle, the environmental dimension of Lisbon and the EU 2020 strategies. So it is very much forward-looking, and on the basis that there isn't going to be that much massive change within the EU, but we want to be looking ahead. And as I say, the detail, what I was very impressed with, right at the end, there are in fact a whole series of points. In the very final page, the author makes 3 main points about the challenges. Do have a look at those, because I'm not going to cover them in this review, but it does look at where the EU is going. And finally, a very detailed bibliography. She's done a wonderful job, and I hope this book is very, very great assistance to people as political scientists and lawyers, scholars, of course, people dealing with jurisprudence. I think it's an excellent contribution to the continuing debate, and thank you to all concerned for assisting us in what is an interesting and moving times. Thank you very much. Bye-bye.